Good day, Crime Talk aficionados. It is Saturday. That means one thing. It's the Week in Review, a compilation of all the top stories located in one convenient place right here on Crime Talk. Hope you enjoy it. Thanks for watching. We'll see you next time. The first case on the docket is the Watts house. That's right, the home of Chris Watts and Shanann Watts, where Chris Watts strangled his pregnant wife, Shanann, to death and then killed his two young daughters. Well, that house is being listed for sale kind of secretly, and they're asking for bids of $660,000. The 5-bedroom, 4-bath home in Frederick, Colorado was originally listed under a fake address, and the agent notes that there will be limited showings of the home to buyers with funding commitment letters for the full asking price. As you may remember, like I said, Watts strangled his wife Shanann, who was 15 weeks pregnant with their son, inside the home on August 13th of 2018. He later smothered their daughters, Bella 4, Celeste 3, and the Watts home was foreclosed upon because obviously Chris Watts spent the rest of his life in prison, will never get out, and defaulted on the mortgage. Now, the listing photos show that not much has been changed in the property since the Watts family lived there and passed away there. Well, the Watts and his wife bought the home for just shy of $400,000 in 2013, and the property was listed in auction in 2019 after the homicides. But not surprisingly, no one bid on the property. Now, at the time of the homicides, Watts was having an affair with a work colleague. At one point, he alleged he wouldn't have killed his wife, Shanann, and their two girls if, he hadn't met his mistress. One of his fellow inmates, a guy by the name of David Carter, claimed that Watts told him that he killed Shanann because he didn't want to pay child support. He didn't want the son that they were expecting and feared that his wife would basically take him for everything in a divorce. Let me know. Would you live in that home knowing that a murder has taken place, specifically that of Shanann Watts? Let me know in the comments. Let me know if you think somebody should buy it, do something nice with the property. Lori Vallow's own son, her oldest son, Colby Ryan, he's 26, and he is speaking out about his mother and saying some not very nice things. Now, he still has problems accepting the charges against her. I'm sure that'd be hard for anybody to know that your mother could kill your siblings, right? Kind of hard to come to terms with. And obviously, everybody knows she goes to trial in October, and she is charged with the killing of her two children, Ryan's sibling, Tylee and JJ. Now, as people may recall, the siblings vanished back in September of 2019, and Ryan said that his mother, Lori Vallow, refused to tell him what was going on for months after their disappearance. Ryan said that he asked his mother at least 100 times what is going on, and the only answer that she would give is everything will be revealed soon. Now, pretty early on, he apparently reached out to his mother, and she was being shady about everything before she cut ties with everybody, including him. When asked what is going on with his brothers and sisters, and if they were in fact alive, Ryan said he never believed that his mother, who was he thought he was close to, was capable of murder. Ryan never knew his biological father, and he and his mother moved around the country rather frequently. Ryan said he thought his mom leaned on him for emotional support, forcing him to grow up a little faster. Ryan also said that he and Lori Vallow had a special bond, which felt more like friends. She would take him to do fun things, and then they faced everything together. Ryan said this bond broke when Lori Vallow married her third husband, Joseph Ryan, Tylee's biological father, who he alleges physically and sexually abused him. Then around 2006, Vallow's fixation with doomsday cults began, so Ryan according to his words, moved out. When he was around 11 years old, Ryan said he believed everything Lori was saying about doomsday cults because he trusted her. It wasn't until he turned 17 or 18 that he decided to live his life the way he wanted to live his life. And he says that he can't live his life of impending fear of something that's going to happen.
He just said he couldn't live like that. It made him absolutely anxious. So he never bought in the idea that the whole world was going to come to an end. When he heard about his mother's crimes, Ryan said that he was overcome with anger and his mother for taking his family away from him. He said he actually contemplated finding a way of seeking revenge, but realized that that was not the answer. Ryan, now father of two, says he constantly misses his siblings, Tylee and JJ, and but added that part of things in life are that you need to let them go. If you're holding on to things like that, you just wish you were here. He said that he loves them and misses his siblings. Even though his mother could face the death penalty, Ryan says that is somewhat hard to accept, but he did say, I've given up the fact that it's not going to change anything no matter what happens. I know they're in jail. I know they can't hurt anybody, and that's the best that he can ask for. So, Lori Vallow's son, Ryan, obviously, he gets it. He knows his mom's not coming home, and he also sounds like he had, a pretty dysfunctional childhood because maybe mom was a little dysfunctional early on. But the key thing here is that guess what? He could be a witness against his mother because anything she says can and will be used against her. And if the district attorneys did not already know about these statements, these are statements that the district attorney could call Ryan to the stand to testify against his mother and say, what did she say when the children were gone? Don't worry about it. They're fine. Guess what? Shows consciousness of guilt, ladies and gentlemen. Listen, this is not a whodunit, so to speak. There's a conspiracy charge. So if one person did it that's charged or an unknown, unindicted co-conspirator, they could all be found guilty as well. So just interesting that Lori Vallow's own son doesn't trust her. Well, guess what? Probably chances are pretty good. Neither should we. And then next we have the Josh Duggar case. Rhymes with hugger. That's how we all remember that it's not Josh Duggar. That's right. Well, guess what? He's been sentenced to 12 and a half years for downloading and possessing inappropriate images of minors. Now, Mr. Duggar, he's 34, and he's been in custody since his federal jury trial in Fayetteville, Arkansas didn't go his way, where he was found guilty. Now, prosecutors say the father of 7, that's right, 7 children, used the desktop computer at his car dealership to search the dark web for the worst of the worst inappropriate images of children. Duggar had allegedly, and the jury concluded, that he had downloaded over 600 images of children being abused, some as young as 7 years old. And Duggar's wife, Anna, as well as his father, Jim Bob, were among the family members in attendance at the courthouse there in Fayetteville, Arkansas today. Duggar's mom, Michelle, and wife, Anna, both wrote letters to the judge pleading for leniency. And I've read those letters. They were some of the worst mitigation letters I've ever seen. Maybe I will pull those and we can talk about those tonight and simply say what not to say when you're writing a mitigation letter, that he's like a really good guy and he's clean. Well, charges did in fact merge. So the judge basically sentenced on the most serious charge, which was appropriate. The prosecutors asked for 20 years. The defense asked for 5 years, and he got 12 and a half. Now, I'm going to have Frank roll that video because remember, we went through the analysis of what I thought Mr. Duggar would receive for sentencing. If he goes to trial and he were to lose, his guideline sentencing range would start at 108 months, right? What is that? 12 times 9, 108, right? About 9 years to 135. You can do the math, about 10 and a half. It can also go as high as 235 months, which is the maximum. That is how Josh Duggar is going to be advised by his attorneys as to whether he goes to trial or enters a plea. And if he goes to trial, remember, all of a sudden now, he's at 12 years, and he can always be up to 20. I think I was the closest. I was closer than the prosecution or the defense. That's why if you want real analysis as to what's really going to take place in a criminal case, this apparently is the best source of information, not a bunch of speculation for sure. Well, it's Lori Vallow. As we've talked about, there was a motion pending by the prosecution to continue the October jury trial date that was set for Lori Vallow and continue that jury trial date to the date of Chad Daybell, which is January 9th of 2023. Well, you would think, what's the problem with that? Well, Lori Vallow wouldn't waive her right to a speedy trial. Therefore, the judge was forced to set it sometime in October within the statutory 6 months that the state of Idaho requires that a criminal defendant proceed to trial. Now, the prosecution made several arguments trying to convince the judge to grant a motion to keep these trials together and basically saying, hey, judge, it's no big deal because this has been done before. Now, we've done videos on this, so I'm not going to go over all of the points, but generally when a state seeks a continuance beyond speedy trial, it's usually a couple of days, maybe a couple of weeks. Maybe you know that witness, you're going to find them, that essential witness. That's right. But in this particular case, the court is moving the trial some 90 days. And Lori Vallow has not agreed to waive her right to a speedy trial. And so the judge basically said, well, close enough for government work. And where I think the judge may have created an appellate issue in this particular case is that Judge Boyce has basically said, you know, these trials would have been set together, but there was a delay caused by the defendant in this particular case, Lori Vallow. I'm going to disagree with the judge, but guess what? He's right because he's the judge. And remember when I say judges don't like to reverse themselves because it makes it look like they're being wishy-washy and that they were maybe wrong in their initial decision? Well, remember, Judge Boyce originally said these cases will be joined for trial, even though Lori Vallow was at the state hospital being restored to competency. So the court goes on in its analysis of this order that the court issued, basically stating that, well, Lori Vallow caused the delay. Well, normally when the court finds that the defendant caused the delay and therefore speedy trial is waived or they're going to extend it beyond the statutory date is when, you know, things happen like the defendant fails to appear in court. The defendant has absenced themselves from the jurisdiction, i.e. the state. And that usually happens after someone has entered a plea of not guilty. The delay was no fault of Lori Vallow in this particular case. In fact, the court notes that Lori Vallow's attorneys filed a motion to have her evaluated regarding competency, which they have an ethical obligation to do. They did it pre-arraignment, so I'm not sure how the court can say that somehow that what the attorneys were doing to make sure that, I don't know, a defendant, even accused of doing heinous things, should still be able to understand what's going on in the court proceedings and assist her defense. So I think the judge messed up right there. We'll only have to wait and see. Now, Mr. Archibald basically said, Judge, I could use the continuance, but I don't have authority to waive speedy trial because that is the decision that Lori Vallow has to make. The court explicitly notes in only one sentence that Lori Vallow has not waived her speedy trial rights. In fact, he states that she has unequivocally asserted her right to speedy trial. And then basically says, well, she caused the delay close enough for government work, and it would be inconvenient to do two trials after all. And this is a death penalty case. And because of the rules that the state of Idaho has put into place limiting the defense team that has to be death certified, that usually requires an investigator and a mitigation expert to even be paid until arraignment, well, we're going to look out for the defendant in this particular case. Now, what should Mr. Archibald do? In my humble opinion, I think he should write a response saying, Judge, I'm asking the court to reconsider. My client has a 6-month statutory right to a speedy trial, and we are asserting that right, and I will be prepared to proceed. And every date that goes past the 6-month speedy trial date, Mr. Boyce should object at the court proceeding, stating that the court has no jurisdiction because speedy trial has run. He needs to raise that on every day of the court appearance. He needs to raise it at the appropriate time for the motion of judgment of acquittal, as well as at the close of all evidence. And that will be appellate issue number 1. Guess what appellate issue number 2 would be if Mr. Archibald does not assert Lori Vallow's right to a speedy trial? That's right. Ineffective assistance of counsel. Okay? Mr. Archibald has a duty to be prepared within that 6 months. And yes, he can ask for continuance, but only if the client agrees to that. And when they don't, guess what? Guess he better get permission from the court to hire a few more people to help get up to speed on the case. We'll see if I am right or wrong. Only time will tell. Judge Boyce did what most judges do, and that's try to make the government's job easier, even if it sometimes puts their entire case at peril. Remember, if, let's say, Lori Vallow is convicted, and she more than likely will be, and there will be an appeal, and if the appellate courts decide that the court violated her right to a speedy trial and set her trial outside of that 6-month statutory date, guess what? That's right. All charges would be dismissed for violation of speedy trial grounds. And then we'd have to see if the Court of Appeals would have the guts to do that, given it's a death penalty case. We will only have to wait and see. Anyway, it looks like the CrimeTalk team will need to make reservations for that January 9th, 2023 trial date with Lori Vallow and Chad Daybell. Let's open the record. First, it looks like there were some serious mistakes in Uvalde, Texas. Texas police said that they did not immediately rush in to find the shooter on Tuesday's attack after being shot at because they feared they might be killed, and even suggested that they deliberately locked the gunman in the classroom where he slaughtered 21 people in order to trap him. Now, Department of Safety officer Lieutenant Chris Oliveris made the astonishing comments during an appearance on CNN. He was being challenged by Wolf Blitzer over why the first officers who responded to the shooting retreated after Salvador Ramos, coward, shot at them with an AR-15 and then waited an hour for the tactical SWAT team arrive to take him out, referring to Salvador Ramos, that coward who kills innocent children and teachers and women there in the classroom. That left him alone in the classroom with the 19 fourth graders and 2 teachers who, like I said, were slaughtered. Police originally said that the gunman barricaded himself inside the classroom and that the police then had trouble gaining access to the room, and one unnamed law enforcement official anonymously spoke out to say SWAT teams had to wait for a different school staff member to bring them a key to the classroom. Scores of Border Patrol agents also rushed to the scene after hearing the incident unfold over their scanners. When they arrived, the Uvalde Police Department also told them not to go inside. Eventually, the agents joined parents and a handful of local police officers in pulling kids through the windows from the classroom. The agents said they did not understand why they were being told not to go inside when the gunman was still in the building. An ex-instructor for the National Tactical Officers Association stated that we don't expect police officers to commit suicide in doing it, but the expectation is that if someone is about to harm someone, especially children, you've got to take immediate action to make that stop. Now, surgeons at the hospital in Uvalde have also suggested that the delay in responding to the shooting may have cost some of the children their lives. The Texas Director of Public Safety literally broke down in tears as he admitted 19 officers stood outside the classroom where the gunman in Tuesday's shooting had his victims trapped and did nothing because they thought everyone inside was already dead. Despite the fact that there was ongoing 911 calls from inside the school and the classroom where children were begging for help. Now, Colonel Stephen McCraw made this admission at a press conference on Friday afternoon when he said that the wrong decision was made, and it came as a result of the chief of the Uvalde School District Police Department, Pete Arredondo, mistakenly believed all of the children in the classroom had already been killed. Police said they thought that every shot that the gunman fired after that was aimed at the door, designed to keep the police officers away. That is just that just gets me fired up. If you watched our show Wednesday on our live program we did during the week, it just irritates me that Salvador Ramos is a coward. He should be forever known as being a coward. And it's kind of sad that some people think that the police didn't go in because they were afraid of risking their lives. That's their job. The police officers that did go in, those SWAT team officers, my hat is off to them. Sad situation. Nothing good comes from that at all.